And if you look at the phone, the type of phones that the accused persons are using, Robert, the first suspect, is using a Nokia Kabambe. Nokia Kabambe, Your Honor, has no capacity. You can't access internet using such type of a phone. And Your Honor, the same IO, investigating officer, said very well that these two suspects are capable of interfering with the witnesses. And the witnesses that we always have in such cases, Your Honor, are always police officers. Thank you very much, Your Honor. Your Honor, to reiterate on what my learned counsel has talked about, that the accused persons were arrested on the 24th day of June, and they are being presented before you on the 26th day of June, which is infringing on the rights of the accused persons, because, Your Honor, Article 49 of the Kenyan Constitution states clearly the rights of an arrested person, that an arrested person must be produced before a competent court of law within 24 hours. And further, that arrested person has a right to bail or bond. And Your Honor, you see the two accused persons having been arrested from 24th, they were denied even a police bond, knowing very well that they are persons who are known, well known in this country. And therefore, Your Honor, we are being told by the investigating officer that they have an application before you, a miscellaneous application, to further hold the accused persons for 10 more days. Your Honor, it's like we are doing things in a very opposite way, because the right way to do things according to the rules of natural justice is to investigate an offense or a crime and then make an arrest. But in our case, the IO was not even sure of the type of an offense to investigate, because they arrested first, then they come before you, Your Honor, with very flimsy reasons. They are on a fishing expedition to tell you that you be part of infringing on the rights of the two accused persons, that they want to hold the accused persons for a further 10 days without proper reasons. And that the first reason they are telling you is that they want to subject the exhibit, which are the phones, to forensic analysis. Your Honor, this can be done even in the absence of the accused persons. And if you look at the phone, the type of phones that the accused persons are using, Robert, the first suspect, is using a Nokia Kabambe. Nokia Kabambe, Your Honor, has no capacity. You can't access internet using such type of a phone. And the second suspect, Suleiman, is using Nokia C1, and this person is not on X, he's only on Facebook. And what is brought? The second suspect uses that? Nokia C1. The first one is Nokia? Nokia Kabambe. And then the second? It's Nokia C1.
It's the other way around.
Yeah. They are waiting to record statements from key witnesses in the investigation. Your Honor, since when? Because we ought to have assumed that they've finished with their investigation they are bringing a proper case before you. And they want the suspects to be present when they are recording statements from key witnesses. And, Your Honor, the same IO, investigating officer, said very well that these two suspects are capable of interfering with the witnesses. And the witnesses that we always have in such cases, Your Honor, are always police officers. So we ask ourselves, Your Honor, that the other day, there's a suspect who was arrested in a police cell. Albert Ojwang was arrested, put in a police cell, and is alleged that he was killed by a police officer. And therefore, Your Honor, if we leave these two suspects in the hands of the police officers, they are dangerous people, because they are supposed to protect life and property, and it is alleged that they took life and property. They took life, sorry, and also property, because some property of the arrested person were missing. So therefore, Your Honor, this is a police officer. These are police officers who are armed. You are being told, Your Honor, and the state is wasting the court's resources by us sitting here a whole day. You're being told that these two gentlemen can interfere with police officers who are custodians of guns. And even if they were capable, which they are not, we have witness protection that can take care of this. And they are not proving the compelling reasons why the suspect should be held for a further 10 days. And Judge Ibrahim, as he was then called, in a case of the Republic versus Danson Ngunya and another, in 2010, described a right to bail as an inalienable right by holding that for you to prove compelling reasons, you must show that there is exceptional circumstance. In the case of the two suspects, there is none. Or unusual. This is a very usual case, which to some point was also declared unconstitutional, depending on how they will prove their case. And ordinary circumstances. And extraordinary circumstances, sorry, which is strong, rousing interest, attention, conviction. None of this, Your Honor, is watertight to justify the two suspects being held by the police officers. Another reason, Your Honor, we are being told about antecedents. That the two suspects were arrested before, that they are habitual offenders. Your Honor, you know very well that every case must be treated with its own facts and merits. And even if they were convicted, which they were not, in the previous offenses, which they don't have, they've never been arrested, then it means that they already served. They already dealt with that case. And this is a fresh case that is before you, Your Honor. And this reminds me to bring to your attention a case of Mills versus the Queen. A case of contemporaneous similar fact evidence. that Mills used to commit an offense, used to murder children in a bathtub and bury them around the house. Mills was arrested, charged with murder, served. Common law precedents. So, Your Honor, to drive my point home, there's a time that somebody else killed in a similar way, but the authority went for Mills, arrested Mills, charged with murder, was convicted. But on appeal, it was found that it is not Mills who killed, or he was wrongly charged for that matter. So therefore, antecedents does not apply here. Another reason that we could be told that the two suspects are flight risks. Your Honor, the officers, police officers, arrested the two suspects from their houses, which means that they are aware, they know that they have a fixed abode. We can't be told that they don't have somewhere to stay or somewhere they'll be found, or they will run away. And Your Honor, even if that is the case, then the two suspects are Kenyans. They can deposit their documents in court, or they can report to the nearest police station depending on the direction that the court may deem fit. Therefore, Your Honor, as I finish, I want to say that this application, the IO is on a fishing expedition. The application is vexatious. It is lame. It is flimsy. It is limping. And it is an abuse of the court process. Thank you, Your Honor. And I request the court to release the suspects on a free bond.
This is the ruling of the court. Now, this court, on the onset of reading the application and hearing counsels for the suspects and the defense, deems that this matter has key issues to be addressed. Now, these are the following orders that the court has made: that the suspects, having interrogated both suspects, be put at Capitol Hill Police Station today, and I'll deliver a ruling tomorrow, the 27th day of June, 2025. These are the orders of the court. Okay? So I would want to assure and I pray that you will be safe until tomorrow. I take judicial notice of the sentiments by the counsels, and I will give a ruling tomorrow, the 27th day of June, 2025.